Assalamu alaikum and welcome to this episode of Sharia Intelligence, where we will be looking at the same subject we've been handling over the last couple of episodes, subject of Qawaid al-Fiqhiyya, Islamic legal maxims. With me to discuss today's topic would be two of our top facilitators, Brother Nasir Bello and Sister Salatu Suleh. You're both most welcome.
Thank you.
One of the maxims we want to look at today is a maxim that we've already touched when discussing the universal maxim al-yaqeen la yazulu bi-shak, that certainty is not overruled by doubt. We touched it also while in usulul fiqh discussing istishab, where we looked at the presumption of continuity or legal presumption, and the maxim states al-aslu fil ashya al-ibaha, that the premise of things is permissible, that everything is halal except what is haram. When it comes to a lot of questions we find within the Muslim community dealing with so many everyday life mundane issues, this maxim comes up again and again as one that people need to understand or have some concerns about. How can everything be halal except what is haram? Is it really a fundamental teaching? Is it a fundamental maxim that is so important? I'd like to first start with Malam Nasir. What exactly does this maxim mean? Why is it important before we go into the evidence for it?
Alhamdulillah, the maxim al-aslu fil ashya al-ibaha is categorized as the general maxim of usul. It is a maxim that is setting the moral and of course legal presumption of permissibility, choice, accommodation, freedom of all things as the default hukum. It's actually a sub-maxim under the second maxim we discussed earlier in Al-Qawaid, which is al-yaqeen la yazulu bi-shak, that is, certainty is not overruled by doubt. And what this is saying is that certainty regarding presumption of, we are more certain about permissibility as the basics, as the default, than prohibition. And you find scholars regarding the issue of permissibility as being the default position of everything, particularly in the areas of mu'amala, agreeing. So there is sort of a consensus among scholars when it comes to the issue of mu'amala.
Mu'amala, you mean?
I mean issues of mundane worldly activities, transactional issues,
as opposed to
devotional act of worship, okay, where you find difference of opinion among scholars regarding the application of this principle of permissibility. Essentially, in the domain of mundane transactional worldly affairs, there is consensus among scholars regarding permissibility as the default hukum. But in the areas of worship and ibadah, there is difference of opinion, when a group of scholars would still accommodate or consider this maxim being the default position, that is permissibility. Others will think differently. The maxim al-aslu fil ashya al-ibaha is one of the most important maxims, particularly when answering questions about Islam and dealing with new Muslims, because it helps, it demonstrates the problem with coming from the other side, that is trying to look at the default position as prohibition, and how it is contrary to other maxims, that because it is different, it is contrary and it creates a problem. If you look at the angle of maxim of ease in hardship, the maxim of removing harm and what and so on and so forth. And if you look at the approach of Rasulullah sallallahu alaihi wasallam, many traditions, you will equally see it appearing as problematic. What seems obvious is what the maxim is trying to demonstrate and explain: that accommodation, that flexibility, that synchronicity between the nature of human being changes and dynamics in time and places with the default position on permissibility. And by implication, what this maxim is saying is that the onus of responsibility of providing proof is attributed to prohibition, not permissibility. That haram by implication is equal to is attributed to sin. It means speaking in God's name. It means shirk or restricting something that is halal. And as we know in usulul fiqh, that requires evidence. That requires evidence. You have to bring a proof that will clearly, in fact, you have to bring something that is certain, that is taking you from that position, that established position of permissibility of al-asl fil ashya al-ibaha that we talked about. Again, what this is telling us is that anything that is not haram, based on this explanation we made of haram implying attributing sin, implying speaking in God's name, anything that is not that, it means it is in fact halal. And therefore halal, given as we said, many reasons, reasons from the text that establish that particular maxim, it means that permissibility does not require any textual. That maxim of permissibility as the default position does not in fact require any textual evidence to be depended or to be supported. That means silence also, by implication, it means silence or ambiguity in the text does not necessarily mean haram. What it implied is there is a space for ijtihad, because then you have to look at many variables. It does not imply that whenever there is silence in the text or whenever there is ambiguity, it's a bit cloudy, that you automatically conclude that it is haram. Or you have a new case or a new situation that perhaps has no any direct backing or support from the Quran and Sunnah, then you assume that it is automatically haram. That is not what is implied. Basically, halal is considered to be the default position until and unless you are able to find any fault in it.
This is interesting also because, as you've already implied in what you've said, when it says al-asl fil ashal ibaha, ibaha belongs to the category of mubah. In other words, there are those things we've already discussed in the past, like things that are fard, compulsory, things that are recommended, mustahab or mandub. There's the haram, what is prohibited and sinful if committed. There's the makruh, the disliked. And the mubah is that which is neither encouraged nor discouraged, just permissible. The freedom of action, freedom of adoption, freedom to do, freedom not to do. And that asl is ibaha. In other words, it's when somebody is attributing haram if you do something, or it's haram not to. So you're saying it's fard or you're saying it's haram. Then the onus of proof is on the person who is saying there's a restriction to the original default freedom. And as you've also mentioned, that rule of istishab, the reason why there's already a legal presumption is because of all the evidence, which I hope we will look at soon, that establish that the asl is ibaha. That the premise in istishab is that everything is permissible except what is prohibited. Sister Salah, what more can you tell us about this maxim?
The maxim actually reminds me of a common law saying that anyone accused of anything is innocent until proven guilty. And this maxim is essentially saying that everything is permissible unless proven otherwise. So every matter is halal until proven to be haram. The value of the maxim is it helps one look at and assess the validity of a fatwa. If a fatwa is given that something is haram, or there is a sin upon people who don't do a certain thing, just going by this maxim, understanding the maxim, understanding other maxims related to it, helps one understand that this fatwa is something that is rooted in these core principles of Islamic jurisprudence. Another thing that's valuable about this particular maxim is that it protects certain things. It protects that human freedom to be innovative, to use the risk, the things that Allah has provided, to come up with methods, processes, ways of doing things, whether it's ways of managing people or managing places, ways of eating or preparing dishes. That freedom of choice is there, and this maxim protects it. This maxim also protects diversity, that not everyone has to do a specific thing. Because in a number of cases where people swing to haram without proof, is when they see something that's new or different or strange. They are not used to it, and they think, okay, if we have proof for what we are familiar with, this is new, it's not what we already know, so reject it, it must be haram. This maxim helps to protect that diversity of thoughts, of opinion, of perspectives as well. Another thing about the maxim is that it helps people be more respectful of the cultures of others, of the ideas of others, of the usages and customs that exist within industries or different fields. So it promotes that mutual respect among people. It also helps reduce racist or tribalistic leanings in what we accept or what we value, not to look down on things just because they are different and ascribe to them the haram factor. We are speaking, yes, of freedom and saying al-asl, the default position in everything is ibaha, permissibility. It's worthy of note here that we are still responsible for the choices we make, for how we exercise these freedoms. As we mentioned before, all maxims work together, because for some people, their fear is if you say everything is permissible, it would make people too wild. It will make people disregard those bounds that Allah has set. It will not happen once people are fully respectful and take full responsibility for understanding these freedoms and what they are meant to achieve. Ultimately, it's about living a good life. It's about benefit. So those are the points I would like to add.
Thank you. I think this last point you touched on of appreciating the creativity in others. You know, sometimes you find Muslims wanting to come up with an Islamic solution to something, an Islamic way of doing something, when instead of getting creative, what they probably need is just a bit more humility to check and do the siru fil ard, travel the earth, look into, do the ta'arafu, know about other customs, other cultural ways of handling mu'amalat, and probably somebody else has discovered the medicine that Allah has put as a qadr for the disease that He has created. And so the need, I think, for that recognition of the, as you put it, the positive mental attitude we should have towards newness, towards different ways of doing things in mu'amalat, and recognizing that everything is halal, ibaha, acceptable, and especially if it is useful, if it is beneficial, then you find, as you put it, a full consensus among scholars that it is halal. While on that, could we look at the kind of evidence, Sister Salah, that scholars bring to give authority to this maxim? And what would be the limitations? What would be areas where scholars would differ in the application of this maxim? But let's start with authority.
Okay. Let's look at a couple of verses of the Quran. There is one where Allah mentions, actually He asks that who has forbidden the embellishments, the beautiful things, the beautiful gifts, the adornments that He has provided for us, and those tayyibat, and those pure, wholesome, in this case wholesome things that He has provided for us. And this verse was revealed with regards to a practice among the mushrikeen, that they had their own way in those days of circumambulating the Kaaba, not without wearing clothes, in their birthday suits. And so the question comes up to remind us that we have been provided with things. We've been provided with things that we can use for our benefit. We have clothes, so wear them. You've got wholesome things, use them. We have that. Then we also have another place where Allah is saying to the Prophet ﷺ, and by extension to all of us, that there isn't in any of the things revealed something that's not allowed for people to eat, except, and here the exceptions are outlined. And scholars then underscore the fact that that verse starts off saying there's nothing that's not permissible for us to eat, except, and then the exceptions are carefully mentioned. Again, going back to this al-asl fil ashya al-ibaha, as we said when we started talking about the qawaid, every one of the maxims is an expression, is a summary of the meaning of a number of verses in a hadith. Then to mention some of the hadith that go with this, it's this one I think mentioned earlier on, that it's the one who is claiming that something is haram or something, this is its condition, that should prove it. The person who is making the assertion should prove it. So if we start off with the premise that everything is permissible, the person who then says, but that is not permissible, is the one who should bring evidence for it. The onus is not on someone to show that something is halal. The onus is on showing that something is haram. And that again reminds me of the common law saying, also a maxim, that the one who asserts must prove. Especially where they are looking at what is the equivalent of Islamic laws, istishab, where this is the status quo. If you are going to assert something different from the status quo, prove it. You are claiming that that house does not belong to that person by right, you prove it. You are asserting that this person stole from you, you prove it. Another hadith is this whole, the one where we are told that there are things Allah has made clear. There are things that He is silent about. It's not out of, error or forgetfulness, subhanallah, but it's out of mercy. And in that space of mercy is where we then operate. So for many scholars, they would say where you see that there's silence in the text, then the premise is permissibility. But as you mentioned, scholars agree on this principle with regards to mu'amalat, social transactions. That's where they have unanimous agreement. That when it's a matter of social transactions, mundane affairs, matters between people, as opposed to when it's matters of ibadah, devotional worship, that when it's mu'amalat, all the scholars are of one voice, that al-asl fil ashya al-ibaha. Of course, there are some nuances, but generally speaking, they agree on that. So when it comes to matters of trade, dressing, food, transportation, business, public administration, healthcare, education, those issues, it's taken that everything is permissible. That is the default position. And the exceptions that exist are exceptions that are clear from strong evidence. The exceptions have been outlined and they are based on textual evidence. Their disagreement, the divergence in their views, arises when we are talking about ibadah, devotional worship.
So if we can pick on that, Malam Nasser, could you say more about this issue of what some scholars view as an exception to the maxim? That when it comes to things that are beneficial in mu'amalat, benign, they are harmless, they are useful, the general rule on every aspect of life, socio-economic, political, cultural, entertainment, sports, etc., is everything is permissible except what is prohibited. But what are some of the exceptions to this general rule in the view of some scholars?
Yeah, as you rightly mentioned, that in the domain of mu'amala, to a large extent, that is the default position, that is the applicability of this very important maxim. However, you would find existence of difference of opinion among scholars when it comes to applying this particular maxim in the domain of ibadah. For example, issues around adhkar after prayer, the numbers of adhkar that you are going to do, the formula, how you do it. You would find scholars differing, while others will feel it's okay for you to do it whichever way you want, what you even recite in the azkar. Others will feel this is the domain of restriction, as the case may be. Or the areas that are called quasi worship, the areas that have sort of a blend of aspect of mu'amala and ibadah, like the issue of celebrating Mawlud, where you have all this element coming together. There also you have existence of difference of opinion among scholars, while some will still go ahead and see the applicability of this very important maxim. Others will have some discussion around that. Although we actually established that in the domain of mu'amala there is sort of consensus among scholars as to the application of this particular maxim, but you will find in some very small areas, like in the areas of sexual relations, the issue of abadan and the issue of luhum, you would find discussion among scholars as to come in on the opposite. Even in fact in the discourse around luhum, some will not have much problem when it comes to the applicability on consumption, but slaughtering could be the area of discussion and debate among scholars. One interesting thing with this particular maxim, it is so strong, so powerful because of the support it has from many verses, many ahadiths, so much so that all restrictions in both ibadah and mu'amala on this particular maxim are debated among scholars. And again, another thing that is interesting about it is you would find most of the restrictions or most of the debates around this as simply semantics, but at the end of the day you would find that still the validity or the implication of this particular maxim is really visible in most of these areas if you look at the preponderance of evidence.
Mashallah. I think, as it said, a maxim is a general rule with few exceptions. And if we look at our daily lives, most of what we do in the economy, in the politics, in administration, in our careers, communication, innovation, entertainment, most of our creativity and activities belongs to the area of mu'amalat. And so this maxim is the general rule. And inshallah, we will come to the exception to discuss this issue of acts of worship or devotional acts of worship, ibadat, or what some would call deen in the narrow sense of the meaning, in a subsequent episode. Here, I'd like to focus just on an understanding of what scholars have a general agreement over when it comes to the application of this maxim. And what I'd like you to, starting with Malam Nasir, help us go through is we have learnt a lot about what you call the various parts of the engine. What I would like us to see is how does the engine work? When we say istishab and we say everything is halal except what is haram, from the time you ask a scholar a question, is having a wedding anniversary halal? Is having a wedding ring halal? Is eating kangaroo meat halal? These areas where, or a particular new type of fruit, a durian or some other fruit that we've never come across before, anything in the area of mu'amalat, I like the idea of kangaroo meat, for example, would that be considered halal? And how would scholars move in a sequential method? If you're looking at a diagram or a flow chart, how do they move from, is this thing halal or haram? How do they apply the maxims? Where would they start to differ until they finally tell you your answer? So just to go into the head of a scholar, how is this, what are the protocols? How is this question processed?
As we mentioned at the beginning, this very important maxim is critical to answering questions generally about Islam. And by asking about process, basically, it's just to imagine what happens in the minds of scholars when they are asked questions about Islam. Usually what happens is, if you look at it in form of steps, the first step will be to ask himself or herself, is it the domain of mu'amala or ibadah? If it is in the domain of mu'amala, usually the default position is permissibility. Everything is permissible, and that leads you to the next step, where the application of this legal maxim that is in the domain of mu'amala, everything is halal. Now, if it is in the domain of ibadah, that is where, as we earlier mentioned, you have disagreement among scholars about it. Now, the second step now is, okay, it is in the domain of mu'amala, where you have that understanding of general permissibility. Now, could there be an exception? That is stage 3, where is there any Quranic text that is what we call qat'iyyu thubut, qat'iyyu dilala. Since it is a Quran, that you have no problem about the establishing it as qat'iyyu thubut. Now, is the dilala also very explicit? It is very clear. If you have that kind of evidence from the Quran or any evidence from Sunnah Mutawatir that is qat'iyyu dilala, that is making an exception to that general permissibility in this particular case, then you say, okay, you've arrived at your answer. However, or something that falls within the fundamentals of religion, where establishing certainty as to the ruling is critical. So essentially, it's a question of, do you have any qat'iyyu thubut, qat'iyyu dilala that is taking you from this yaqeen of established permissibility as the default position in your stage 3? If you don't have it, then you move to stage 4. And what you find in stage 4 is scholars differing because it is now the space of ijtihad. And in trying to do ijtihad, since you've already passed the stage of something that everybody agreed upon as the basis for making an exception, then you would find different schools of thought coming up with different tools. And that by implication will mean the outcome will be different. You will see Hanafi coming with their istihsan, you will see Maliki coming with amal, and of course you will see Shafi'i coming with their ijma, with their qiyas, for example. And then you will find Hanbali coming up with Sunnah Ahad. So there you will begin to see difference of opinion regarding what the exception is. And at times it will be a full cycle. If you didn't get anything, and that is in line with what we earlier mentioned about silence in the text does not necessarily mean prohibition. If you go around all this and you could not find anything that is clearly prohibited, then it still goes back to the position, that position of it being permissible. So that is how scholars usually go through or go around these steps in trying to arrive at a position when issues come up or when question is asked. So basically, like we said at the beginning, you still stick with your permissibility, you still stick with your halal position until and unless you are able to get a convincing, certain exception to that particular rule. Otherwise, it still remain halal. Allahu ta'ala alam.
This is interesting. So going step by step again, what you're saying is when a question is asked, the jurist wants to find out or categorizes it. Is it ibadah or mu'amalat? If it's ibadah, then he knows there's going to be some difference of opinion. If, however, it's kangaroo meat or durian or some function, something that's clearly under mu'amalat, the first is to find out first the recognition that it is permissible, it is halal, except if there's evidence that it is haram. If it's not haram clearly from the Quran or Hadith Mutawatir, then they would have to go to other sources. But if it is haram from the Quran and the Hadith Mutawatir, then all scholars would recognize it is haram. So if somebody was asking about pork, for example, it's under mu'amalat, everything is halal except what is haram. So you would go, is there prohibition in the Quran? Yes. Clear, categorical, every scholar agrees it is haram, every scholar agrees alcohol is haram, etc. But if it is not haram from those sources, that are qat'i thubut, qat'i dilala, certain regarding their meaning and authenticity and all of that, then we look at the secondary sources. But as you've mentioned, once you start looking into the secondary sources or the dhanni sources, whether it's ahad hadith, whether it's amal ahl al-Madina, whether it's qiyas and ijma and all of these tools, and various scholars put them in differing orders, you're going to most likely be ready. I think you should be ready for differences of opinions. If, however, from all of these secondary sources of evidence, there is no evidence that durian is haram, there's no evidence that wedding anniversaries are haram, there's no evidence that kangaroo meat is haram, then the default istishab that everything is halal except what is haram. We've not been able to get evidence for that exception from the primary or secondary sources. So what you're saying is the ruling goes back to everything is halal as the default legal presumption.
Exactly.
Now, Sister Salat.
I think probably before going further, the point from the very beginning is, like as we establish, that what this principle is saying of al-aslu fil ashya al-ibaha is certainty of permissibility. Certainty of permissibility is what is known, and it is more considered to be the default. Now, that position, that understanding in the domain of mu'amala can only be displaced by something that is having greater certainty. And that is why you pause at the third stage, trying to look at this Quran, Sunnah, Mutawatir, Qat'iyyu, Thubut, Qat'iyyu, Dilala, because that is the stage of, having greater certainty or equivalent of what you have that is backing of this, that is establishing the permissibility of the issue in question. The moment you cannot find something at that particular stage that will do the job of creating an exception to that particular situation, then you swing into the domain of, zan, where it's about presumption. And therefore, it's okay for you to disagree with whoever, because there is that element of speculation. It is not clear cut. And it's just like saying, okay, a dad in the house will give an instruction by saying, okay, you keep something somewhere, and you say nobody takes it from where it is, except if I am the one doing that. So he didn't come back. The eldest son in the house or any other person made an attempt to do that, and maybe somebody is responsible for guarding this particular thing. You are not our dad, and the instruction is very clear that it is only our dad that can take it. So the only thing that will move that particular thing from the position it is to another position is if your dad comes in, or maybe his elder brother, who is more powerful and much more stronger than he is, come to that particular place and say, okay, move this thing from this place. Or if somebody that is maybe a son in the house or somebody much lower in rank comes, he needs to present an argument that is convincing, and that is where we begin to look at the domain of effect, harm, because it's harmful because of this. And even at that, it is subject to convincing the person in charge that, okay, this is enough an evidence to shift from what is actually the earlier position. And even if he accepts that, somebody will not agree with him. So that is what makes it a domain of actually disagreement.
And some would then probably say, just to pick on that metaphor, that if the father said something and he's not around, then some would say, well, that's the last statement. Others would say, but if his wife, if his wife is around, then she can represent him. If his father is around, then we can go with that too. And probably where scholars would start to differ regarding, okay, in the absence of clear prohibition from the Quran and Hadith Mutawatir, how much authority is given to the other sources?
Exactly. And I think that is the area where somebody will say, okay, the wife? No. Somebody will say, no, not the wife.
Yeah.
She shouldn't be the first. Okay, his elder brother.
Yeah.
No, but his first son will also will fit in, because at least he knows his dad. So this kind of, okay, who
is next highest authority that could represent?
Yes.
So let's assume, so if we don't find any evidence, I think we go full circle. From everything is halal except what is haram, let's see if there's any exception to the halal. In other words, if there's evidence for haram in the Quran or Hadith Mutawatir, and then we look at all the other, we know if there's agreement here, then everybody agrees, nobody needs to go anywhere else. But if there's no agreement here, then we're going to find differences among the jurists. We'll most likely find differences among the jurists, not necessarily, but if nothing there, then it goes back to default. Everything is halal, so go ahead and eat your kangaroo. Go and just make sure it's slaughtered in a halal manner, or depending on your views on that.
And I think this is even usually what obtains in administrative processes, for example, or management in some cycles, where something will be proposed and they will say, is there any objection? So meaning if there is no any objection, then we
go back to istishab.
Exactly, we'll go back to istishab. It stands the way it is.
So let's assume if there was a verse of the Quran, if there's a hadith or a secondary source, starting with, if there's a clear verse of the Quran prohibiting it, then nobody will argue. If there's a clear hadith mutawatir, nobody argues, it's qat'i thubut, qat'i dilala, it'll be accepted. If it's not clearly prohibited there, but there is a basis for a prohibition in one of the secondary sources. So let's take, or even a primary source, but dhanni evidence, like an ahad hadith, a solitary hadith. What would happen? What would the scholars do?
Well, if there is a clear prohibition of something based on hadith ahad, because of course that, as we discussed before, means it is it has that dhan element in it, dhani thubut. It therefore would mean that what the scholars will do will depend largely on how they view ahad hadith. What position does that hadith hold in their equations of proofs? Because they give weight to the ones that they use first, that come before, in that just as the metaphor that Brother Nasir used. Some would view ahad hadith as a suitable next tool to rely on, others might not. So you might then say, if we use that hypothetical case, that if it's the Shafi'i madhab, following the Shafi'i madhab or the Hanbali madhab, they would consider that particular thing to be haram. Even, because they would look at that ahad hadith and give it the weight, because in those two schools, they can make something haram on the basis of ahad hadith. Independently. Now, if it's the Hanafi, they would not make it what we call clear haram or haram simpliciter. They would instead they would turn it to makruh tahrimi. Makruh tahrimi, yes, it has a makruh meaning it's forbidden, but the tahrimi meaning it is not just ordinarily forbidden. In all, for all intents and purposes, this thing is forbidden. The only reason that they are not calling it using the word haram is because they acknowledge the dhan element of ahad hadith. Now, when we come to the Maliki school, it depends on which trail or train are we following. As we know, for the Malikis, amal of the people of Medina holds weight, weight, and they would look at that, especially in cases like this. So if that's for someone from the early school of the Maliki, they would look at the amal of the people of Medina, and if there's nothing there to guide, then they would say, okay, this is halal or mubah, permissible, like it's fine. Nothing is supporting it, nothing is against it. So they would sort of fall back on that permissibility, al-asl fil ashya, al-ibaha. Now, if it's the later school of the Maliki, they would also still consider amal, but because we are talking of later school, they would then say, you know what, this thing is haram. Just treat it as haram. If you're looking at the majority of the Malikis, the majority of them, they would prefer to say it's makruh. So you find these differences coming up among the different schools, and the variation, the divergence in opinions, even for within a single school as you have in the Maliki school, is because, as we mentioned before, when you have ahad hadith, then there's that element of dhan, and once the element of dhan comes in, then scholars take various positions. That's how they would handle this. Yes.
This is interesting because I think in a more practical case, one sees this on carnivorous animals. So, for example, would it be permissible to eat a fox, for example? Istishab would take it that everything is halal except what is haram, and so you would say, well, it should be halal. But when you look at the Quran, there's no clear prohibition of eating carnivorous animals in the Quran. If you look at mutawatir hadith, there's no prohibition. So it would have just gone to, it is still halal because there is no prohibition from the Quran or hadith mutawatir. But when we look at the hadith ahad, there is a hadith where the Prophet ﷺ said you shouldn't eat birds of prey, that is birds that have talons, or animals that have canines. So the general understanding was carnivorous animals, land animals, not fish, these ones. The understanding of most scholars, therefore, is we do have an ahad hadith that makes it haram to eat a fox. However, because it is ahad hadith, the Shafi and the Hanbali consider it haram to eat a fox or a lion or a bear or a cat, etc. The Hanafi consider it makruh tahrimi for the same reasons you gave. They still consider it haram, but not with the level of certainty that they would get or they would put for something like pig that is clearly from the Quran or the Sunnah. But the Malikis, you find a differing set of opinions. For most of them, they would just say it's makruh, prefer to avoid it. Some would put it as shaz, more ambiguous, this prohibition, because it is not supported by amal. Some of them would even bring hadith to the, or actions of Sahaba to the contrary. But some would say it is still haram. Most would say it is makruh. So here we find the moment you move into that dhanni form of evidence, of dhanni thubut or dhanni dilala or a combination, the need for this respect for the diversity, not because the scholars are ignorant of the hadith, but because they differ in the kind of authority they give the hadith, especially if it hasn't got supporting evidence from other sources like maslaha, etc. And we're just using this for a simple example. But of course, to let everybody remember, just knowing how istishab works is not a shortcut to being a mufti. It's probably just a shortcut to knowing how to ask further questions and make sure you do not start with the assumption that everything is haram, except if it is halal. I'd like to ask Sister Salah, what are some examples of the application of this maxim? So we've seen how it is used. Can you share some examples of how this maxim is used in Islamic jurisprudence? What kind of rulings have come out of it?
Okay. When we look at some rulings that are based on istishab, they are essentially the same, what will I call it, principle in action, because istishab is the legal presumption of permissibility or continuity, that things are as they are, unless you can bring proof that the condition or the situation of a thing has altered. And al-asl fil ashya al-ibaha is simply saying more or less the same thing, but it's qualifying the condition of things, especially as we mentioned with mu'amalat. The condition of things is permissibility, and that continues and remains unless there's clear proof otherwise. Another way in which it's applied is when it comes to the issue of food. Is this kind of food or that kind of food or that sort of food, is it halal? The legal status, default position is all food is allowed. What is prohibited is very clear, and those exceptions, because they are clear, cannot, so haram cannot be extended by default. And lastly is when we look at the area of governance, types of government. I know there are many Muslims who have heard and some who have said that democracy is un-Islamic. However, when we understand this principle, what is democracy? Is it ibadah or mu'amala? It's mu'amala. Okay, if it's mu'amala, it means everything about democracy is permissible. Al-asl fil ashya al-ibaha. It's permissible. And if there's any element in democracy that is said to be haram, then there should be proof for that. So issues to do with voting, with the constitution, or codification of laws, or deriving laws for the society. What else would we put under democracy? Division of power, separation of powers, and those other factors. If one looks at all of these, the question would be, who says it's haram, and the person should then bring proof. Of course, some might cite things like when it comes to voting, you have bribery going on. Then we would say it's the bribery that is haram, not the democracy. Or they might say some laws are made that go against Islamic laws. They are in direct opposition of those. It's the laws that are haram, not the democracy. Because when we look at things like bribery or laws that go against Islam, if you check even Muslim governments in Muslim countries with a majority Muslim population, you still see bribery going on, and you would still see laws being made that run counter to Islamic principles. If we go into history, you even find great scholars who had run-ins with the government of the time, with caliphs or amirs of the time, Muslim leaders in Muslim countries, where the scholar would have to speak the truth to power and say, that is wrong. That ruling you just gave, that instruction you just gave, that is haram. So when we see, and this is why we said earlier, Al-Asl fil Ashya al-Ibaha helps us to be open to what is of benefit and to take that as a default position. So if we see a system of government or a system of administration or a system of anything, the question we should be asking ourselves is, as the system is it okay? And if you cannot have proof that something is clearly haram, then you take the default position. Al-Asl fil Ashya al-Ibaha.
It's interesting, because if one links it with a maxim that was discussed earlier on under Al-Yaqeen la yazulu bi-shak, I think it was under Al-Umur bi-Maqasidiha, that matters are judged according to their purposes. One of those maxims, or a couple of maxims that were raised, was al-ibra lil-haqiqi la lil-alfaz, that what matters is the reality, the essence of things, not the words used. And so when it comes to things like democracy and capitalism and secularism and socialism and Marxism and liberalism and constitutionalism and feminism and the long list of things are out there, it is really useful, especially when these words mean different things to different people. Democracy in one place is different from democracy in another place. Secularism in one place accommodates religion. Secularism in another place is against religion. It's more atheistic. Yeah. So when we look at what is socialism, what is capitalism, and we, different definitions of these things, it is useful for Muslims to recognize that when something is mu'amalat, while not automatically endorsing anything, the need to look at the components and be able to distinguish, as you gave, say, democracy, what is Islam's position on democracy, instead of just saying this is the answer, where some would say no, to go down to the elements. Is it separation of power? It's mu'amalat, everything is halal except what is haram. And let's look at what is the evidence for haram. Is it the legislature and the lawmaking process that is haram? Then we would be able to identify what exactly is haram. Is it the term of office? Is it this? Is it that? So I think the key thing about the maxim is setting the default starting point. Instead of starting with haram, unless there's evidence for halal, once something is mu'amalat, once something belongs to the worldly, mundane, interpersonal transactions, the need to respect the maxim in our methodology of analysis, whatever that conclusion is going to be, but it is on the onus of the person prohibiting to bring the necessary evidence strong enough to justify a haram, and one can then be comfortable one is speaking in God's name if one has the prerequisite evidence. As we come to the end of this, Brother Nasir, what other examples can you give us in the application of this maxim?
Well, I think before adding some more examples, just to speak to this issue of trying to be more careful and critical in dealing with these issues, and not actually assuming that it's just simple, that supposition that, okay, everything is halal except what is haram, so everything halal is simple. I remember one interesting story. One of our teachers was saying a scholar was traveling and he decided, okay, he wants his dad to come and sit on the seat where he teach his student, where he give fatwa. And so he said, but I'm not a scholar. How do you want me to deal with that? He said, no problem, I will give you a trick. What you should do is, whatever question you are asked, just say, on this particular issue, there are two opinions. A group, the one group said it is halal, and the other group said it is haram. في المسألة قولان منهم من يقول بتحليل ذلك ومنهم من يقول بتحريم ذلك. So sometimes things are oversimplified. But if you look at it carefully, particularly these steps that were itemized and outlined that usually scholars follow, usually if you get to the level 3, where you are trying to find whether there could be any reliable, certain evidence that will make an exception to this principle, and you could not find it, particularly with issues of mu'amala, the next stage you will get into is the domain of dhanni, issues of difference of opinion. And there, what you find is an area of risk assessment. It's about assessing the harm and the benefit to a large extent. And that is where you find on certain issues, it's not just the domain of religious scholars. It's the domain that requires expertise from different fields, because you have to measure, okay, is it really harmful? Are these issues really systemic that you need to even unpack them, like the democracy issue we're talking about? Is it the entire democracy or the entire Western education system, or is it the entire capitalism as a system that is problematic and therefore should be thrown away? Or maybe some aspect of it that you feel is problematic. Could it still be democracy without that particular aspect? If you are able to establish and convince me, even able to convince me that that aspect is really harmful, and the level of harm falls into this category is so glaring and so visible that it falls into this category of ad-darar yuzar that we discussed earlier, or it's something that still is issue of perspective and it can be argued differently, it could be seen differently. So this idea of unpacking systems and trying to go to details and trying to differentiate, get to the level of expertise and knowledge where usually in societies like ours, you find religious discourse approaching these issues with some level of ignorance, really, in understanding and appreciating the depth of this concept. Now, coming back to the question you ask, of course, you would find lots of examples when it comes to application of this particular maxim, particularly in a world that is evolving rapidly, that is so dynamic. Things are coming out. You know, the world that we call the VUCA world, where it is highly volatile, uncertain, ambiguous, complex. Things are really changing. You cannot predict what happened tomorrow. A lot of things are coming out that you see the relevance of application of this particular maxim. Look at, for example, this idea of cryptocurrency today. It's an entirely new thing. So of course, the default position is al-aslu fil ashya al-ibaha, and that's what you will see from the fatwas that scholars are giving. Because at the end of the day, it is a whole new concept that you don't have anything, any precedence that clearly comprehend or imagine this particular scenario, let alone trying to have something that is clear cut on it. So it gets to the issue, domain of Zanni, which itself we already argued and established that it's not enough to make an exception. And also you get to the issue of harm, risk assessment. And another good example is this idea of, can you stun an animal before slaughtering just for you to ease the pain, and of course to simplify the process of slaughtering? Can you these issues of genetically modified crops that you are seeing, the question of productivity, yield, in a world that food security is becoming a very, very important issue. The issues around women, can a woman be a witness in a crime? Because what you find in the classical books usually is that women are restricted because of the culture of those particular contexts on areas of witness they can and even then you will find some classical scholars that are really referring to this al-aslu fil ashya al-ibaha on that permissibility. Can they be witness? Can they hold position of authority? Can they be leaders? Can they be judges? Can a woman slaughter haram or a cow? All these kind of things are some of the issues that you can see clearly the application of this very important maxim of al-aslu fil ashya al-ibaha.
Thank you so much on this. It's a very rich world of so many things that belong to mu'amalat. And yes, as you've mentioned, al-asl fil ashya al-ibaha. At the same time, you also alluded to the need for caution. When you don't know anything about cryptocurrency, is it halal or haram? Yes, as the jurists, they operate on it is halal, let's get evidence for it being haram. And if you don't have any evidence, then your position is not to say it is haram. It's either I don't know, I'm not sure, or it is halal. However, just like with biotechnology, genetic engineering, in a context where we're very concerned about food security, we're very concerned about a few companies controlling the food security of nations, a few corporations running the world in this area. There is the need to not be lazy in digging into especially the tools of maslaha, of saddu zariya. In other words, okay, it is halal by default, but let's look at the cost-benefit analysis. Let's look at the impact assessment. Let's look at the benefit and the harm. Everything with advantage has some disadvantage and vice versa. Just so as not to say because it is mubah, then it's okay without cross-checking. As some scholars would put it, silence in the text of the Quran or Sunnah, silence means a space for ijtihad, a space for the jurist to be concerned about the welfare of the community and not just say yes without checking to ensure that experts in the field are also saying yes on something. And I recall something that we touched on in a few episodes before, that for every issue, especially in areas of mu'amalat, is this halal, is it haram, to be first clear, what do you mean by what you have said? You know, what do you mean by what you're talking about? So that it's not just big words. You hear people, pluralism, is that halal or haram? What exactly do you mean? Citizenship, is that halal or haram? What exactly do you mean? And a lot of these terms, so where do you, what do you mean by what you're talking about? And the need to break things down, Western culture or Nigerian culture or African culture. Is there even such a thing?
Restructuring.
Yeah, exactly,
Or young people would ask, is going to a party, is it haram?
Exactly.
And sometimes if your first thought is what you know of a typical party, alcohol, and, illicit relations and all of that, the temptation is just to say, yes, it's haram. But then they come back at you with, but what if all we are doing is just hanging out and just having fun? Then, then you learn over time to say, hold on, when you say party, describe the party you have in mind.
Exactly.
Because it even helps with the discussion with them. Just describe what you have in mind. Precisely. And even when they themselves utter certain things, as they're uttering it, they realize, that is not okay. Yeah. That is not okay.
Exactly.
And so on.
Exactly. So this whole issue of, what do you mean by what you are saying? So when we say al-asl fil ashya al-ibaha, everything is halal except what is haram. The premise is permissibility. Still good to interrogate, what are you talking about? And if you're going to say it is haram, to be sure, where do you get your evidence from? Is it Quran and Hadith mutawatir, for which there would be consensus if the dilala is explicitly clear, the implication is clear, or is it coming from any of the other sources where you may have differing opinions? And to really look for evidence before we venture into speaking in God's name. There's a responsibility to have a quality of evidence strong enough to say there's a sin that Allah places on this action before you say haram, because that's the implication of haram. When you say something is haram, you mean Allah will punish it unless He chooses to forgive. To speak on behalf of Allah requires evidence that we shouldn't play with. And if one is not sure, then one would rather just say, I am not comfortable with it, but don't speak in God's name without the prerequisite authority. I'd like to thank you all for your contributions. Jazakumullahu khairan. Until next time, Assalamu alaikum wa rahmatullahi ta'ala wa barakatuh.